Hear me. All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Well, welcome to the Massachusetts Appeals Court on this Friday, April 7th, 2023. I'd like to wish everyone a solemn Good Friday, a blessed Ramadan, and a happy Passover. The panel today is myself, Justice Ditkoff. To my right is Justice Han, and to my left is Justice D'Angelo, and we'll be the panel for all four cases today. I know you're both very experienced, but for those who aren't, each side will get 15 minutes. There's no rebuttal. There's a clock up there. It will start counting down the time from 15 minutes. When it gets to 90 seconds left, it will turn yellow. When it gets to 0, it'll turn right and start counting up on how much time you're over. When the light turns red, you may finish your sentence, but please don't say anything else unless you are responding to questions from the panel, in which case, please finish your answer and any other questions the court may have. As you know, we have definitely read the briefs. We've read them carefully. We've looked at the records so you can get right into your argument. With all that being said, I'll call the first case today, which is Commonwealth v. Anderson, 21P1124. Before you start, I'll note that the Commonwealth did not file a brief in this case. They filed a memo in lieu, and thus is not entitled to argue. But we appreciate the ADA being here. I suspect we will have questions for the ADA afterwards, and that is how we will proceed. Counselor, whenever you're ready.
Good morning. May it please the court, Esther Halpern for Mr. Anderson. This court is to decide whether the judge erred when the judge denied the motion for new trial, which was ascended by the Commonwealth. And the Commonwealth wrote a rather persuasive response to the defendant motion, explaining why it's assenting to the motion. This case involves the Hinton lab and the misconduct that was revealed after the defendant pled guilty in this case. The Commonwealth, specifically the district attorney, announced that it would consider the Hinton cases between specified years, if the substance was analyzed within the specific years, as class 2 according to the Bridgman protocol.
And counsel, this was irrespective of whether the drug certificate in this particular case was signed by Annie Dugan in any capacity, is that right?
Yeah, well, that was the decision of the SJC. But the position of the district attorney was that all the cases that the evidence came from that period of time, from the Hinton lab, it would serve the public interest.
Was the SJC's decision concerning the lab at issue in this case?
I'm sorry?
Did the SJC's decision discuss the lab in this particular case specifically?
Did it concern this particular, this case? Yes, this case was the Hinton lab case.
Okay, but was that the SJC's decision? Was the Hinton?
I'm sorry, I can't
Okay,
hear you.
let me ask another question. Is there any question here that that Annie Dugan signed the drug certificates here?
No.
Okay, thank you.
So it specifically actually invited the defendants that have a case that falls within this category of cases to file motions with the court so that then the district attorney can move to no pros those cases.
Is there any authority that says that if a district attorney assents to a motion for new trial, the trial judge has to accept that assent?
No, there is no case that says absolutely the court must allow the motion. There can be cases, although I have not found a single case where the court actually says, no, the judge was correct. The judge could, if the judge found that the district attorney had corrupt motive or motive that is against public interest. And the cases say only in the cases like that. The court could
what case is that?
There are no Massachusetts cases on this. They just.
Okay, what case, you said the cases, so there must be a case somewhere that says only if the Commonwealth is agreeing to vacate the sentence for corrupt motives, you can deny it. So what's that case?
That's actually in the federal case, Rinaldi, for example.
But that case said that was not a valid reason to disagree.
That's a Supreme Court case.
Yeah, but it seemed to say the opposite. In that case, the judge had denied the motion to vacate on the grounds that what the government was doing was improper, and the Supreme Court seemed to say that was an abuse of discretion to do it on that, to refuse to vacate a defendant's sentence because of what the government was doing.
The conduct of the government.
Right.
But in the case, and the cases that it cites, the only explanation why, in the federal cases, the Supreme Court was actually interpreting the Rule 48 of the Federal Rules of Procedure, which provides that the government can move to dismiss with leave of court. And the court was interpreting leave of court. And it says that leave of court are interpreted to mean to protect the defendant. For example, if the defendant was convicted and appealed, and then the government realized that the evidence was insufficient and is likely to win on appeal, and it would then move the government to dismiss, so it can dismisses this conviction, so the government can get another bite at the apple. That would be improper, and that's how the courts would interpret. But there is no case specifically saying that it's just the verbiage in the case. It's just interpreting the rule. But the Massachusetts courts has specifically said that you could have the prosecutor could move to vacate the conviction or agree to the vacation of the conviction if it found, for example, that the case was convicted, the defendant was innocent. And in an era where we know that there are many cases where after a conviction, the defendant is then has shown that he's innocent, to prevent the government from to assenting to a motion, especially where here the government...
No one's saying the government can't move. I mean, the government can move. No one's saying the government can't move. Judge Ullman's just saying he doesn't have to accept that.
Well, again, there has to be... The cases speak about the federal cases interpreting the Rule 48. Speak unless there is a substantial showing that it's against public interest.
Right, but our rule says a prosecuting attorney may enter a no prosecute of pending charges, and these weren't pending charges.
That's correct. Those are not pending charges. This was already a conviction. But what was unusual about those cases, and it's not one case, it's many cases, a number of cases, where the government is said in their response to the motion that essentially they would not have prosecuted Mr. Anderson had they known about the misconduct, but they didn't.
Well, that's what this district attorney said. The issue is our rules, as Justice Didkoff just said, A prosecutor can't null pros a case without a judge's granting a motion for new trial once there has been a conviction.
Correct.
And the
that's-
public policy behind that may be because district attorneys change. And just because one district attorney has a viewpoint, another district attorney might have a different viewpoint, and they just don't want cases being changed just because of the whim of the district attorney. And at least my search, I can't find any state that allows, on the party of the district attorney alone, to allow a motion for new trial without a judge stamping allowed. Would you agree with that?
I haven't found a case that says the opposite, that where the court found, it would have to find some corrupt motive. There is never explanation, well, this district attorney decided to do this, and in fact, sort of luring in defendants to file those motions, and then something happens, like in this case, another district attorney now says, we don't have a position. They took a position. They took a position, and nobody should be allowed to in the middle of the game to change the rules. And that's what they did.
But at the point that the district attorney in this case took a position, to Judge D'Angelo's point, the conviction had already taken place, so it was no longer the DA's discretionary call, correct?
There is an issue of that the judge, without any hearing, how can the judge decide anything if the judge doesn't even hold any kind of hearing?
Did you argue that here? Is that part of your appellate argument, that there should have been an evidentiary hearing and wasn't?
I'm sorry, I'm sorry, I didn't understand.
I didn't recall reading in your brief that there was an argument challenging Judge Ullman's decision based on his failure to hold an evidentiary hearing. Did I miss that?
My position is that what the judge had before him was a compelling case where the position of the Commonwealth was clear, explained, there was no bad faith, there was no improper motive, and explained we would not have pursued those cases had we known what was going on because we think it's unreliable.
Let me ask it this way. The SGC has told us that even when the Commonwealth concedes error on appeal, that we have to independently review whether that concession is warranted. And in at least one case I found, McCollum, we decided it wasn't warranted and affirmed a conviction even though the Commonwealth was conceding. So why is this different? Why is Judge Ullman not in the same situation that we're in when the Commonwealth says, oh, this should be reversed?
Well, this is not a confession of error. I mean, they're not saying we made an error. It was an abuse of discretion to rule the way the judge ruled because there's nothing in any case that allows the judge to use his discretion to overrule what the position of another branch of government, executive branch of government, decides to do.
I don't see how he's overruling it. Two parties come in, they both want something, but the judge thinks they're not entitled to it. That happens in courtrooms all the time. Two parties come in, they both agree on something, the judge says, no, that's not what the law requires, we're not doing that. They're not overruling the lawyers or the executive branch, just saying, no, I'm not convinced that that's what I should do as a judge.
What is the basis? To use discretion, you have to say why you feel that this is an incorrect position of the government.
Well, the judge wrote...
What makes this evidence in the judge's eyes reliable when the prosecutors who prosecuted and who reviewed thousands of documents, the judge didn't review? And very often, actually, the prosecutor will have information that they, for reasons of investigating another defendant, another suspect, they can't reveal to the court. So and
It sounds like you're putting the burden on the trial judge to put forth reasons as to why he should deny the motion, as opposed to your burden as to why the trial judge with evidence should allow the motion.
well, when the Commonwealth tells the judge, this evidence, in our view, after we now know what we didn't know before, is not reliable, there's no basis for the judge to say, no, I think it's reliable. There's just no basis for it. And to exercise discretion in such a situation, it's an abuse of discretion. And I would ask the court to reverse the judge's ruling, denying the motion, and order the court to allow the motion, and that the prosecutor then should file a no pros as they said they would do. That's my request. Thank you.
Thank you, Counselor. All right, well, you can introduce yourself. Sorry.
Thank you, Your Honor. Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth.
Thank you. As I said, because the Commonwealth didn't file the brief, and I know you weren't involved in that decision, you don't get to argue, but you certainly get to answer questions. And I would like to say that we appreciate, Mr. McGowan, I know how busy your office is sending someone here and you preparing to be here. We see that as a sign of respect. I can't say we're very happy with this motion, memo in lieu that doesn't take a position, but I know you weren't involved in that decision, nor was anyone who's even still in the office. So we are where we are, but that's not the kind of thing we like to see here. So I do have a question. I suspect my colleagues do as well. But is this still the policy of the Suffolk DA's office? If someone came in now with a non-Dukin certificate, would Suffolk agree to the motion?
Your Honor, my understanding is that the office's current position is under review, as there are a small series of cases in the Suffolk Superior Court that are similarly situated. And the current administration is evaluating the position of the prior administration and has not yet reached a conclusion on what position the office will ultimately take going forward.
Again, as Justice Ditkoff said, I know you didn't write a brief, but the testing in this case took place on July 29th, 2011. The judge's findings say, and I quote, "There has been no subsequent finding of misconduct by any other chemist at the Hinton lab during the relevant time period," end quote. Is that still accurate?
It's a tricky question. I would say yes. The Office of the Inspector General has released a report and a summary of that report of their thorough investigation of the Hinton lab, and at the end of that report, they indicated that their conclusion was that Annie Dukin was the sole bad actor chemist. Within those series of 3 cases that are currently in Suffolk, and then there's a cluster of cases in Middlesex as well, they've obtained some discovery regarding the OIG's investigation into the Hinton lab, and they've concluded or realized that within the scope of that investigation, there were 3 referrals made from OIG to the Attorney General's office for possible criminal prosecution. But that doesn't necessarily mean that there was any wrong action on the part of those chemists where those referrals were made. It just means someone conducting an investigation at OIG of the Hinton lab thought somebody should look at this and see if there's criminal conduct here. But it's my understanding that there has not been anything substantiated in any way, shape, or form. So as things stand right now, as far as I understand, Annie Dukin is still the sole bad actor in the Hinton lab during that time frame. Sonia Frock's conduct, different lab, different time frame.
But it sounds like you're also not sure there isn't any other misconduct, just none that's been brought to your attention.
That's correct, Your Honor. I mean, I am assigned to the cluster of 3 cases at the Superior Court level for Suffolk, and as well assigned to the case in this court that's currently stayed, Nova, and they're all relatively similarly postured. None of them were tested. My understanding is none of them were actually tested by Dukin. They were tested by other chemists, but within that time frame, when my office under the prior administration had that policy of assenting to what the prior administration determined was egregious governmental misconduct on the part of the lab writ large, as opposed to any one particular chemist. So when Judge Ullman evaluated my office's assent, he looked at that and said, well, you guys may have assented to there being egregious governmental misconduct under the Ferrara-Scott test, but I still have to evaluate whether there is. And it's a motion to vacate a plea, meaning a motion for a new trial. So we had to look at both the seriousness of the issue and the adequacy of the showing. And while certainly it seems a serious issue, ultimately his memorandum in order seemed to suggest that he felt the showing was inadequate. There was nothing that established egregious governmental misconduct. This case certainly didn't qualify for the presumption, the conclusive presumption, because Annie Dukin didn't sign the chemist. She was neither the primary nor the secondary chemist. So Judge Ullman concluded that this case didn't qualify for the conclusive presumption of egregious governmental misconduct, and they hadn't made any sort of showing to establish egregious governmental misconduct in another way, merely because the drugs were tested during the Hinton lab in the time frame when either Dukin or Farrak worked there. So it seems to me like while my office maybe disagreed with that conclusion, that whether there was egregious governmental misconduct or not, he's free to disagree with us. Disagreeing with us doesn't constitute an abuse of discretion, as we all know. So I think when this court conducts its independent review, it has to determine whether he abused his discretion or not, and disagreeing with us isn't.
Is it fair to say, and if it's not, that's fine, that if there were to be discovered additional misconduct by other chemists, that the Commonwealth would not judge this motion as waiver of a claim based on more information about the Hinton lab?
No, Your Honor, because I think that would be newly discovered evidence, so I don't think it would fit within waiver. And that may well happen in the future coming forward as a result of the ongoing discovery process in the cluster of Suffolk and the cluster of Middlesex cases. But right now, we're simply not there. So maybe this claim will be ripe and valid at some point in the future, but based on the record that Judge Ullman was looking at, the showing that was provided by the defendant, there simply wasn't enough there for him to find an adequate showing to establish a motion for new trial was warranted applying the correct legal test, the Ferrara-Scott framework, which he cited. And Justice Dickoff, he also cited the Lewis opinion that you drafted yourself, where you discussed the difference between the conclusive presumption cases and the non-conclusive presumption cases. So he applied the correct law.
That was a tough opinion. That one took me forever to write. All right.
No questions about the null pros argument about when it applies or when it doesn't apply?
I don't. All right. Thank you very much.
Thank you.
Thank you both. This is a very fascinating case. All right. Well, I would like to welcome our guests from Bentley University. I am afraid, however, that this court is very dependent on public transportation, and there's been some problems with the commuter rail, and we do not have both lawyers for the Tentillo case. So whenever we do get them, we will proceed, but we're going to have to skip that case and go on to the third case, which is Commonwealth versus King, 22P 894. Just give me a second, Counselor. All right, whenever you're ready.
Good morning, Your Honors. Kevin DeMello on behalf of the defendant appellant, Cindy King. Your Honors, trial counsel in this case for Ms. King was ineffective because she inexplicably failed to use surveillance video that would have made a material difference in the case. And at the outset, I want to address something in the Commonwealth's brief that we've actually discussed, that the question of whether there's 3 video clips or 4 video clips at trial. There were 4 video clips at trial. One of them showed Ms. King arriving home. One of them showed...
Oh, wait, at trial?
I'm sorry, at the motion for new trial hearing. They were not offered at trial. So the second clip was of Ms. Sharik's son coming home, and then there were 2 clips of Ms. Sharik coming home, one from the front of the house and one from the side. And I've provided all of those to my brother. He's viewed them. He's conceded that, yes, those were all available to the trial judge when he made the ruling on the motion for new trial. So that shouldn't be an issue that's at issue here. With respect to those surveillance videos, it's our position that they would have made a material difference in the defense in this case.
How do we know that defense counsel saw them?
Well, we don't. What it says in her affidavit is that she remembers viewing some of the surveillance videos, but she doesn't recall any surveillance videos that depicted Ms. Sharik or her son. So that leaves us with the conclusion either she didn't view those videos, or maybe she viewed them and she just didn't understand the significance. In either case, it's ineffective assistance.
Well, but how do we know those are the videos that your client gave to Attorney Hirschberg?
Well, what I would point to are the email communications that I referenced in my brief. In the affidavit of Ms. King, where she's saying she's got a bunch of video. And what I would also say is that as a defense counsel representing a defendant who says, yeah, I've got surveillance at my house, as a defense counsel, I think you'd want to inquire very deeply into that. Get every single piece of surveillance you can from that day.
Well, when your client, who has control over the Ring account, sends you a Dropbox saying, here's all the video evidence, are you really not a competent lawyer if you don't say, well, I want to look into it further and see if there's more? Like, why can't you rely on your client when they tell you that, here's the videos?
Well, I think you have to ask your client, okay, how do these surveillance cameras work? They're motion activated? Okay. How come there's no video here of you coming home? How come there's no video here of Nick coming home? How come there's no video of Ms. Sharik coming home, if those were missing? But I think it would be Ms. King's position, based on what she's provided in her affidavit, that she did provide these specific videos. And even if you can't draw that conclusion from what's here, the counsel should have been investigating this.
What happened to the video of the police officer on the ramp calling the judge?
I don't know, Your Honor. I believe that's a video I believe what my client said was that in some cases, the video capture, because it's motion detection, didn't work. So some of the video, there is some video of police officers outside.
But she says in her narrative, there's a time and date stamped video of an officer on the ramp outside calling a judge. And now we have this affidavit, here are the videos I gave to my lawyer, and it doesn't have that video.
There are more videos that I haven't presented just because I didn't think that they were videos that would have helped at trial. There's a bunch of video here. Like I said, these are motion activated cameras. They capture any comings and goings. So there were, the other part of this is there were many clips. Some of them by this time may no longer exist, but there were certainly more clips here than the 4 that I've presented. With respect to these videos, it's our position that they go to a key issue here, and that's Ms. Sharik's credibility. Specifically, the whole case that the defendant put on about the assault and battery claims was that Ms. Sharik fabricated statements to police to head off that Ms. King was going to obtain a restraining order. And Ms. King sent a text to her on that day, and there's some issue at trial about whether she received the text, and Ms. Sharik claims, well, I left my phone at home. These videos show her entering the home, holding what appears to be a cell phone. So this would have been very powerful impeachment evidence that trial counsel failed to use.
I mean, why is that better evidence than the victim saying that her son called her before she entered the house?
Well, what I would say is a picture is worth 1,000 words, and having it on video is much more powerful than a testimony where she's saying something and she could say, oh, well, I misspoke. The video can't be disputed in the same way. But more than that, Judge, there's other parts of this video, and I think one of the key parts is the issue of the light not being turned on. It's clear from all of the videos from Nick and of Ms. Sharik that there's a front light, that it's never turned on, and that directly contradicts Ms. Sharik's story that she told the jury, hey, I was afraid, so I went to go visit my son, and I told him to go home and leave the light on. Well, these videos directly contradict that. And there was no cross-examination on that issue because there was no ability for trial counsel to dispute that without these videos.
Can you just remind me whether she also testified that she saw the light?
She did.
Okay.
I believe she specifically said she saw the light and she went in. And I have a, page, the first transcript volume, page 86. She says, so that's what he did. He put the light on and I went in the house. So, I mean, that's a story she told the jury that would have been directly contradicted by this evidence. That would have been very powerful evidence to support the defendant's claim and to contradict the alleged victim's story. And it was and she was the only witness to that. She was the only testimony about what happened during the assault and batteries. So it's our position that that's key evidence. There's other stuff in the videos that was helpful, but maybe not as important. For example, the 12-minute gap between when Nick arrives home and when Ms. Sharik arrives home. That may have been something that was easily explainable by Ms. Sharik, but it's also something that could have been ample grounds for cross-examination by defense counsel.
That one I'm not following. This whole thing is a setup. He's going to go first. He's going to look around, see whether she's in bed, turn on a light, make a phone call. Why is 12 minutes inconsistent with that?
Well, if I were defense counsel, what I would have argued was, they leave from his work at the same time. Why is there a 12-minute gap between when he comes home and when she comes home? That seems like a longer period of time if they're both traveling home from the same place at the same time. Again, I think it's not as powerful as the evidence relating to the light, but it's something that could have been brought up as well.
Can you clarify something? In your affidavit, you talked about documents that were in the file you got from Attorney Hirschberg. And it has letters, but there's no letters in the appendix. So I was hoping you could tell me of the stuff in the appendix exactly what was in Attorney. You say it was, exhibits B, C, D, and E, but it doesn't have letters on it, so.
So there's a what appears to be like a narrative from Ms. King. I think that's what I'm referring to when I say a letter. And in that, it specifically talks about, I have surveillance video. And it says it in a couple of spots, and I referenced that in the brief.
Okay, so there's the narrative. What else?
I think when I'm talking about the letter, I think that's the primary one, and then there's an email that's referenced in the email.
The email was in the file?
I'm sorry?
The email was in the file that you got?
The email was provided to me by the defendant, but this is an email that's purportedly was sent to defense counsel. So that wasn't in the file.
All right, so you said, letter from Cindy King, report of hearing officer relating to Lieutenant Giancotti, Townsend Town Meeting minutes, Townsend Town Mead minutes. And the report is that investigator's report we have in the appendix?
Correct.
Okay, and those are the things you had?
Those were all in trial counsel's file.
Okay.
If there are no questions about that issue, Judge, I'd move on to the issue of police bias. Between the judge's errors here and counsel's failures, the jury was left with the erroneous impression that the issues of police bias were generally between the board and police, not specifically between Ms. King and these officers. Although evidence of impeachment was allowed, it was only about generalized animosity. For instance, Officer Marchand admits that there's some animosity between the board and police, but he kind of boils it down to political differences. And Commonwealth picks up on that in their closing argument, said, well, there may have been some political differences between the board and police. Similarly, Lieutenant Giancotti says, well, there was an amicable relationship between board and police. There may have been some issues, but not animosity, he says. Or, for instance, when Ms. King was allowed to testify that the board called the police for help once and Officer Phillips didn't respond. These are all sort of generalized issues. What wasn't presented at trial were specific reasons that these three officers had to be biased against Ms. King. And I think the most egregious is Lieutenant Giancotti, because Ms. King publicly castigated him at a hearing saying, I'm very disappointed in you and I'm going to recommend the maximum punishment. And that's something that gave Lieutenant Giancotti a specific reason to be biased against King, and it's not just politics. With respect to Mr. Phillips, Ms. King voted specifically to investigate him, With respect to,
But that was an executive session the day before. How would he know what had happened in executive session the day before?
well, we don't know because we didn't get a chance, he didn't get asked that at trial, but presumably he could have heard that. This is a small town, people are connected. If it happened, through the grapevine, he very well could have heard it. But it's something that at least defense counsel could have asked about at trial and didn't. Or in this case, he tried to, and I think the judge excluded it. There's some sort of relationship between what the judge did and what the trial counsel did. I don't want to put all the blame on trial counsel because the judge seemed to act very quickly to curtail this evidence, and I think trial counsel may have been sort of trying to comply with that ruling and failing to offer some of this stuff. But
Can I ask you about that? Is your argument that it was error for the judge to exclude it, or is your argument that it was error for the lawyer not to make a better offer of proof so the judge could have made the right decision?
It's both, Judge. First of all, some of it was attempted to be offered, and the judge excluded it summarily. For instance, Giancotti's suspension for truthfulness, Officer Phillips' disciplinary record. Those questions were asked. The judge said, we're not getting into that.
Well, see, I'm glad you gave that answer, because a judge hearing just that there was a disciplinary record, that is seemingly far afield from the issue of bias. So all the judge hears is there's been this disciplinary hearing and he was disciplined. Based on that offer of proof, and I know it was more of an emotion than an offer of proof, the judge probably made the right decision on that, just hearing that. So what is the error here? Is the judge excluded what he heard, but he didn't hear what you just mentioned as why it was so important?
Well, let me first say, I think that's a very good argument. What I would say in response to that is there was some level of the door being opened here. For instance, with Officers Phillips and Officers Giancotti, specifically Officer Phillips denied having any disciplinary issues with the board. He was asked specifically, hey, did you have any disciplinary issues? Denied that there were any differences with the board. With respect to Giancotti, he's saying that they had an amicable relationship. And to say that, and then defense counsel asks, well, what about your disciplinary record before that board? And the judge curtails it. I mean, I think at least that warranted the judge calling them to the bench and saying, what's going on here? Because there was some level of the door being open. But I also think there's ineffective assistance because there was failure to make adequate offers of proof. And in some cases, there was failures to just even try to offer the evidence. With respect to Officer, I think, like I said, the most egregious one is Lieutenant Giancotti because he's a supervising officer on the scene. And Ms. King's comments towards him at that public hearing and her vote to impose the maximum penalty, that's a real reason, and it's not collateral. This is something Ms. King did, and this is a reason he would have for being biased against Ms. King. Likewise, the other pieces of evidence for the other two officers, they're not quite as powerful. Like you said, the vote to investigate Mr. Phillips, maybe he heard about that, maybe he didn't. With respect to Marchand, there was a vote about a grievance. Ms. King voted against allowing that grievance. But again, these are all issues that specifically related to Ms. King. They're not collateral. There are reasons for these three specific officers to have a beef with her. And so our position is that because defense counsel failed to offer this evidence at trial, that it was an unfair trial and that she deserves a new one. And with that, I'll rest on my
Counsel, we don't have any transcript of the August 2nd, 2022 motion hearing. Is that because there isn't one?
There isn't one.
Okay.
It was not an evidentiary hearing.
No, I get that, but often they get transcribed. I just want to make sure not missing something.
No, and to be fair, the arguments were substantially similar to what we're arguing today. I don't think there was anything earth-shattering, other than the issue with the videos, because I did initially submit a USB drive with 3 videos, and then I came to court that day with another USB drive, gave it to the ADA, gave it to the judge, et cetera. That was the only thing that might be missing. And if there are any other questions?
Thank you very much.
That's not my brief.
Counselor, whenever you're ready.
Thank you, Your Honor, and may it please the Court, Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. With respect to the defendant's first argument regarding the ineffective assistance of counsel for failure to use the surveillance video, and I don't know how much more clarification is needed, but there's no doubt that the 4 videos were before the judge at the motion for new trial. It was my error in failing to obtain the fourth video. I think it doesn't affect the legal argument very much, but might affect some snarkiness at a footnote that I would retract. But with respect to that, I think initially, as you touched on, there's not necessarily a showing that this was a conduct falling measurably below a normal trial counsel. We don't necessarily have a factual showing that counsel completely failed to get these videos, completely neglected to view them. It could have just been that she saw them and decided not to put them into evidence. It could have been a tactical decision. I just think, based on the record we have, it's not necessarily clear whether defense counsel viewed these or not.
What would the tactical decision have been there?
I think that, and I was going to say, I think that largely goes to my second argument, which is that this doesn't necessarily, this does not rise to the level of a deprivation of a substantial ground to defense, because these videos necessarily open up the defendant to cross-examination just as much as they help prove or impeach the victim on certain points. And to that, I would point to the first video where the defendant returns home. It appears obvious that the defendant is stumbling up the ramp. I think that really exposes her to cross-examination on, well, this intoxication that was touched upon during the trial, that was apparent. This corroborates the victim's tale of events. I know that the defendant admitted that she had been drinking prior to coming home in her own testimony, but it certainly doesn't paint her in a great light to show a video of her stumbling up the ramp shortly before she goes in and has this altercation with the victim. Additionally, I think the issue regarding the light and whether it was turned on, there's no evidence presented at the motion for new trial that this is the light we're referencing. She means that light. She doesn't mean a lamp that's in the front door. It's a bit tangential. It's a bit attenuated. Yes, we have the video evidence, but ultimately, and I think this is the ultimate point, is that the victim was exposed to cross-examination and impeachment on these issues.
About the cell phone.
The cell phone, the video is not clear that it is a cell phone she's holding, but again, I think that's of marginal value, given that she was impeached on, you said she came home at 6 p.m., but these text messages are time-stamped as, I think it was 5:49. So clearly, you don't remember when she came home. You have a bad memory of when this occurred, right? And then when she's additionally impeached on whether she had her phone prior to leaving. She says, well, no, I forgot my phone, it was on. And then she's cross-examined on whether she contacted the police after viewing the messages. Initially, she says, yes, I saw the phone, and then I told the cops, hey, look here, look at the messages she just sent me. So this theory of defense, this motivation to fabricate these events in order to shield herself from the restraining order from the defendant, that was well presented to the jury. This kind of theory of she had these messages, she contacted the police only after receiving these, and additionally, an additional point is that she's cross-examined on the fact that her son called the police and not her. So her motivation to contact the police was impeached. It was well before the jury that this could have been fabricated to avoid the consequences of the restraining order that the defendant said she was going to get. And so in that regard, I just don't think there can be an ineffective assistance of counsel claim where she's not deprived of any ground of defense. What these could have presented was impeachment evidence. They could have called into question the victim's memory and whether she was motivated to lie about these events, and that had already been presented to the jury.
Counsel, what's bothering me, and what your friend, I think correctly said was pretty powerful, is the Board of Selectmen minutes about the Lieutenant Giaccotti discipline, because that's something we actually know that Attorney Hirschberg had, because it's in the file that successor counsel got. And it's such an easy one, certainly, if you show that to the judge is going to allow cross-examination on that. So that's one I can't see a reason for not using that, but why that's not ineffective.
In terms of not offering the meeting minutes and the
I don't mean offer to the jury, but show it to the judge. Yeah. Say, look, Your Honor, there's a real thing going on between my client and this lieutenant.
And I think insofar as it's a claim that it was a failure to make an offer of proof, I think that doesn't rise to the level of ineffective assistance of counsel, because in this sort of circumstance, an offer of proof is not necessary. It's kind of obvious. She says, he was disciplined for untruthfulness. And the judge says, no, I'm not going to go down that rabbit hole. And so insofar as she doesn't bring forward these meeting minutes and say, no, here's her specific.
But don't you think the judge, if he saw those meeting minutes, would have said, oh, okay, you can inquire about this?
And I think that it was before the judge on the motion for new trial, and I think he determined, and his determination is accorded substantial deference here, that this would not have made a difference. And I think that's because he's entitled to balance the need to present bias evidence, the defendant's right to present bias evidence, with the desire to keep this trial from becoming a miniature trial on Lieutenant Giancotti's disciplinary record.
There weren't findings I missed, were there, by the judge?
On the motion for new trial?
Yeah.
No, it was a marginal notation on the
Okay.
a margin notation endorsement.
When you say the judge said that it would have made no difference, he didn't specifically, my memory is anyway, he didn't say he would have excluded it. What he said was, it wouldn't have made a difference to the jury. Is that fair? And that's different. I see that as being different. If he had said, I would have excluded it because it was extraneous information, etc., he didn't say that. He just said it wouldn't have made a difference. Is that correct?
At the motion for new trial stage, yes, that's correct.
Did he even say that, or are you just inferring?
We're assuming that. He didn't, yeah. But I do think that it is, in excluding it in the first instance, he's at trial. He's excluding the specific inquiry into the details of Lieutenant Giancotti's disciplinary proceeding, including the public hearing. And I think it was obvious that the defense counsel wanted to go into the details of this disciplinary hearing, what he was disciplined for, what his punishment was, which would be wrapped up into what she said at the public hearing. And so he's entitled to weigh that balance between the desire to go down this inquiry into the specific details of his disciplinary proceedings with the desire to keep this trial focused, to not have undue delay, to not mislead the jury. And I think he clearly did not abuse his discretion in doing so.
What about the specific bias that the defense counsel could have shown between Giancotti and the defendant? That's different than just a discipline at a public hearing or so forth. Isn't it fair that the defense lawyer could have used this to say, you just don't like my client, and then used it to impeach him? If he said, oh no, I have no problems with your client.
And I think this is, it didn't rise to deprivation of a substantial ground of defense for exactly the reasons that she did present that defense through her own testimony. She says, I was involved in disciplinary proceedings with these officers. I think the judge said just a yes or no, and she said, yes, I was involved in the disciplinary proceedings with these officers.
I'm failing to see how the judge did not deprive the defendant of specific bias between Giancotti and the defendant. You're saying that the judge allowed sort of this general feeling, which I agree with, he did, with a yes or no, he limited it to that. But this is different than a general bias. This is a specific bias towards the defendant, isn't it?
I think but I do think in that regard he's allowed to weigh whether this is a specific bias. And I guess the point is, did he abuse his discretion in determining that this was not a specific bias towards the defendant? And I think here he's entitled to make that decision. I don't necessarily think that he limited all questioning into the bias towards Lieutenant Giancotti's bias towards the defendant. I think what he limited was specific inquiry into the details of the disciplinary proceedings. So I see the point that if the defendant asks, well, aren't you biased against my client? He says, no, we're fine, and then he limits the impeachment with it. But that's not what happened here. She tried to go straight into the details of the disciplinary proceeding to kind of use it as a prior bad act to paint this officer as a liar. Well, he's been disciplined in the past for untruthfulness. That means you can't believe a word he's saying. And I think in that regard, the trial judge is entitled to weigh the prejudicial value and the distraction and the undue delay in going down that miniature trial on Lieutenant Giancotti's disciplinary record and exclude that evidence. He did not bar all inquiry into bias. He just barred inquiry into going into his disciplinary record. And then with respect to some of the other officers, I think it's important to note, as was touched upon with Officer Phillips, he did not abuse of discretion in excluding that evidence where it was, A, unclear that the officer had even heard of this. It was somewhat conditionally relevant on the fact that Officer Phillips knew that they had voted to make and voted to initiate an investigation into him. There was no showing that...
Is that something that's clear to you? I mean, that it was an investigation of him?
From the appendix?
From anything?
It
I mean, the only thing the appendix says is there's an investigation into the jewelry company's allegations. It doesn't say who.
Yes, and then there was, I believe, the record appendix included a hand notation by the defendant as to, I believe she wrote someplace that this is where I voted to initiate an investigation into Officer Phillips, and I believe it was included in her affidavit as well. But from the meeting minutes itself, from non-defendant annotated meeting minutes, no, it is not clear.
I guess I'm asking, are you acknowledging that that note is accurate?
No. I would just, even assuming that it is accurate, the evidence would still be inadmissible. We had no, if she's going to annotate and say, I voted to initiate an investigation, she could have equally said and mailed him a letter that night that said, we're investigating you. There's no showing that he was aware of this. And so the judge was well within his rights to say that's too attenuated. There's been no showing that he has any particularized bias against you because of this investigation, because there is no showing that he's aware of it. And I think that's even further strengthened by the fact that in the interim between the voting to initiate an investigation and the time of trial, the defendant makes no further showing that and it resulted in discipline or this is what happened. Since that time we know nothing, and I think it cuts both ways. She could have equally gone up there, and in that regard, it could have been a tactical decision not to question him on this, because she could have asked, and you're biased because of this investigation, right? He said, oh, no, nothing came of that. I didn't, it wasn't a thing. They didn't, and in these processes, we don't even know if...
Just to be clear, you don't know either way whether anything came of it.
Correct. Speaking hypothetically, and so it could have cut both ways, and so in that regard, I think it cannot be ineffective assistance of counsel to fail to bring this forward, where it could have equally just exposed the defendant to the answer of, I was unaware of an investigation, I harbor no ill will towards the defendant. It seemed to be a bit of a strategy to kind of keep the waters muddled and say these officers are clearly have a motivation against this defendant. I think that was effectively drawn out by defense counsel. And then if there are no further questions, I would rest on my brief.
All right. Thank you both. This is a pretty interesting case, and this is very helpful, both the briefing and the presentation.
Thanks.
Now, did I see ADA Mello come in? No, I did not. All right, I'm afraid we still don't have everyone for Tentillo, so we will have to go on to Commonwealth versus Green, 20P 503. No, take your time. Get your water. You're definitely going to want that. I could never get through an argument without some water. Not once.
Good morning, Your Honors.
My name is Suzanne Levert. I'm the attorney on behalf of Daniel Green. This case, this very sad case, really involves two tales of what may have happened to to Brandon Green. The morning of November 27, 2012, Sam Green, his mother, brought him for the fourth time to the hospital because she was afraid of his breathing and his gagging, and she was quite concerned. They said, no, he's fine, he has this bronchiolitis, it's common in kids, and sent her home for the fourth time. Later in the day, or in the evening, his father, defending Daniel Green, brought him back to the hospital because he was still not well in his mind. And the hospital records show that he was a well-appearing, healthy young baby. Some words to that effect. And
Can I ask you about this? Because this seems to be some confusion in the trial and perhaps to me. What time did the defendant bring the baby to the hospital?
That is a really good question. The records, the one record shows that it's 7:36, and that is in both, I believe, Dr. Newton's and Dr. Scheller's testimony, but I'm sure it's in Dr. Scheller's testimony. People were having trouble seeing it, and I had it in my record appendix, which was, I apologize for that disaster. But it was about 7:36. And that is important. If you go with Dr. Newton's story, the timing is extremely important. If you go with Dr. Scheller's theory of the case, which is that this is it was not caused by injury, it's an internal disease, and it could have been going on for many...
Let me stick with the timing again, because I agree, Dr. Newton, the timing is important in a light most favorable to the Commonwealth, which is what we're going to look at as far as the sufficiency argument. The argument seemed to be at trial that the baby was fine at 7:36 p.m.
Right.
and doesn't have problems until 3 hours later, approximately 3 hours later.
Actually, if I can interrupt, the records show that it was 2 a.m. when he had his first drop in breathing and his first seizure. So it was a lot longer, which matters if you go with, as you say, if you go with that theory, which was the Commonwealth's contention with Dr. Newton.
And your argument at trial, or the defendant's argument was at trial, that at 2 a.m., if that's when the baby starts to decline, the health decline, that takes it out of the time frame that Dr. Newton says, which is a half hour to, and again, I know there's some between 4 and 5 hours. No matter which one you use,
And
that's
that was
well beyond
at
5 hours.
a stretch. When she said that at the grand jury in a trial, that 4 hours would be a stretch.
But even if we use 4 or 5 hours, because I know 5 was mentioned, that's well beyond when the defendant had the baby. Is that accurate?
Correct. Well, it would have meant that whatever happened to Brandon happened while he was in the hospital. If he got there at 7:30 and it's not until 2 that something happens, then...
I thought the testimony was that it had to happen 30 minutes to 4 hours before being brought to the ER, not before the symptoms showed.
No, before the rapid decline started. And that why the Children's Hospital was called in. That's what she said at grand jury, and I have all the transcripts. My printer broke yesterday. This has been like an amazing...
Did Dr. Newton give any explanation in her testimony as to why there would be the baby appearing fine, and then, whether it be 4 or 5 hours later, there would be this decline in his health?
No. She believed that it could have been 5 hours, but that never made it to 2 a.m., the 5 hours. If the hospital record was correct that he was there at 7:36, then that would have missed the time.
Attorney Liverd, if we read the transcript, and I'm looking at supplemental record 2, page 110, if we read that testimony to say something happened very close in time to when he went to the hospital, within probably half an hour, but on the outside range, 2 to 4 hours, how does that impact your argument?
I believe this, certainly before the grand jury and before the another hearing, her opinion was that something happened a half an hour to 4 hours at a stretch before the decline happened, before he was starting having apneic episodes, before his seizures started. So that was her, I believe that was her approach. In any case, Dr. Scheller has a completely different opinion, is that the baby, which is really documented well in the medical records from Dr. Stockman, who's the baby's pediatrician, was that the baby was born with a very small head, only in the 3 percentile of his age. And then 3 months later, he's at the 50th percentile, which is, according to Dr. Scheller, a notable growth. It struck him.
So is this point going to your argument that the evidence was insufficient at the grand jury and then again potentially at trial?
Yes.
And how do we look at that evidence, though? Are we not looking at the evidence in the light most favorable to the Commonwealth?
I'm sure my brother will take care of that. I'm arguing for my client. And my client says an equally reputable physician, Dr. Scheller, who was graduated from the Detroit Children's Hospital and was a pediatric neurologist, not a child abuse pediatrician, which is the way Dr. Newton described herself. He looked at this, he looked at the same scans as Dr. Newton had and saw a very different approach to the injuries in Brandon's head. And
But counsel, I appreciate what you're saying, but as the fact finder, Judge Ames could have disregarded everything that doctor said as not being credible and relied solely on the Commonwealth's evidence. You would agree that that's what our standard has to be at this stage?
yes, I do agree. It's frustrating, as you can imagine. Dr. Newton, as I mentioned in my brief, has been at the source of some controversy about her opinions. At least one Massachusetts case was dismissed over her diagnosis, and I find, but if we want to use Dr. Newton's theory, then we can go back to the time frame, which is very tedious. And it doesn't also explain, which I think is an interesting thing, I brought it up in my brief, I don't think the Commonwealth addressed it, but Dr. Green, who was Danny's mother, who is a physician, saw Brandon and Danny together on Thanksgiving, a week before this incident. And she noticed that when the baby looked up, he had a left gaze preference. And to her, if she said at trial and at the grand jury, no, I don't know if she tested, I don't know. But at trial, she said Had he been an adult, I would have known what to do. I would have called the ambulance. And she said that haunts me to this day because that looked like a brain injury, that suddenly that's a left gaze preference. And perhaps, I don't think Dr. Newton's theory of the case explains that at all. Dr. Scheller's could. He says we don't know when this fluid started to build in the baby's brain. It could be a week ago, it could be yesterday. We don't know. So I think that adds weight to his testimony. Now, I do need to mention the character evidence that the Commonwealth says was not even in the trial. Well, it was practically the entire closing argument of the
Where in your brief do you tell us what language in particular you take issue with?
I don't remember, Your Honor. Let me no, that's not me. Sorry. When you don't have a printer, your life is over, just to let you know.
That's fine. I think you answered my question, so I didn't mean to interrupt the flow of your argument.
No, that's okay. I'm sorry. Here we go. I think I'm not sure I spelled it out, and I probably should have. I think what I did was point to the insufficient, I admit, record appendix. I've been an attorney for 20 years now, 20 years. 22 years. And this was the most difficult thing, I know, Justice Hand, that you worked to get e-file, you were interested in the e-file project and you worked on it. I had read that in your bio, I think. And I love it 99.9% of the time. This time, I had to file my record appendix 5 times. And when you do that and you take then you take the references out of your brief because you don't know what page it's going to be on. And then you've got to file it because it's the end of the line. And then you don't put the pages in. And then you're just...
The practical challenges, I think, of appeals are, everyone would agree, there are some.
Well,
But
this was...
you have limited time, so I don't want to use up your time on that.
I just wanted to mention that. So I'm not sure that I did mention the words, but they were... I wrote them down because on pages 14 and 15, the Commonwealth's brief said that Danny was miserable, stressed out, struggling financially, working under the table, living in a cramped, cluttered room at a homeless shelter. So he's poor and he's struggling. And this is motive for him to shake his baby so horribly, so badly that a person would be horrified, as Dr. Newton put it?
Because he resented having to take care of the child and wanted to get back with his ex-girlfriend. Why isn't that motive?
To shake a baby? I mean, to leave the family, to abandon the child, I see. But I don't see why it would... He had another child, McKenna, with his ex-girlfriend. And he took care of Lexi, his new wife's daughter, and nobody had a single complaint about any violence toward any child. He seemed to... The only 2 people who testified that they saw Danny with Brandon was his mother, who said he was he appeared loving and great with the baby, fed the baby, picked up the baby, seemed fine with the baby, and Stephen Hall, the respiratory therapist who was there just before they took him to the hospital. And he said he was loving. He consoled the child. The child started to cry. He picked him up and the baby stopped crying. A baby who's been abused may not behave that way. And that's another thing about the Commonwealth's case. They put forward all those things, and it goes on. I stopped, but there's lots more. you know, had child support debt and had this relationship with Greta and wanted to kill himself and hated and was tired of the baby crying. Well, I don't know a parent alive that hasn't been tired of the baby crying. And I just don't see that.
Unless there's any further questions, we'll have to leave it there.
Okay?
Thank you
Arrested
very
on the
much,
brief.
Counselor.
Thank you very much. And I do apologize for the mess with the record appendix. It was appalling to me, and I apologize to the Commonwealth as well, because it must have been frustrating for them.
Thank you.
Thank you very much.
Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. I'd like to focus in first on Justice Ditkoff's comment about the time that Dr. Newton pegged the injury. The record is absolutely clear, both in front of the grand jury and at trial, that she said the injury occurred between a half hour and 4 hours at the grand jury and a half hour and 5 hours at trial from the time that they arrived at the emergency room. Nowhere did she peg the time of injury based on the time that the symptoms, the bad symptoms, started. That's nowhere in the record. Secondly, as to when they arrived, I'm very glad that the Court is focused on that question because the record is not precise about that. I'm not sure where the 7:36 p.m. time comes from. According to my sister today, for the first time, she says that it's in Dr. Scheller's testimony, and it may well be. But I note that in the reply brief, after I had pointed out a lot of deficiencies in the citations of the record, she did not say anywhere where she got that fact from. That aside, the best or the most that can be said about that is even if there was evidence that they arrived at the ER at 7:36, there was conflicting evidence and a lot of evidence that showed that they arrived closer to 11 o'clock. And I have a whole paragraph in which I list all of the evidence, both in the grand jury and at trial, that shows that they arrived later than 11 o'clock.
Dr. Newton testified to 7:36, isn't that right?
No. She said 7:30 or 8 in front of the grand jury. Then at trial, she said, I was wrong about that. No one said 7:36 that I know of, except Dr. Scheller, perhaps. I didn't go back and check. But she never says 7:36. But at the grand jury, she said 7:30 or 8. But as I'm saying, there was a lot of evidence that they arrived much later than that. There's testimony from the officer that Sam had told them that they left at 10:22 p.m. And then I cite all of the medical records that have times on them start around 11:08 p.m. There's an admission sheet, there's a pediatric note sheet. All the times on that start at 11 p.m. And if the defendant and his wife and Brandon had arrived at 7:36, there's no explanation anywhere for what they were doing for those 4.5 hours until he's taken to the pediatric ward. In fact, there's testimony, the defendant in his statement to police talks about how during that evening, how they gave Brandon a bath, how they were concerned about his breathing. So a lot of things occurred within the apartment after Sam got home from the Walgreens that makes it virtually impossible for them to have arrived at the emergency room at 6:37, 7:36, any time like that. But the point is there was contrasting evidence about when they arrived, and both the grand jury and the trial jury could have found that they arrived much closer to 11 o'clock or to 11:30. And there's no dispute that he went from the emergency room to the pediatric ward at just exactly midnight. So that brings from 11 p.m. to 4 a.m. That's the time frame that Dr. Newton was talking about at trial, and till 3 p.m. because it was 4 hours in front of the grand jury, which certainly gives the defendant plenty of time to have injured the trial. Further, there's the insurmountable hurdle that the defendant assumes that the injuries had to occur while the defendant was alone with Brandon. Of course, that's not true. The Commonwealth proceeded on that theory, but both the grand jury and the trial jury could have found, or a rational jury could have found, that those injuries occurred while Sam was either in the bathroom or with him in the apartment. So I don't think that makes any difference.
Can I ask you
yes,
about
please.
that? What evidence is there for Judge Ames to have found that Dad did this as opposed to Mom?
Well, she set them out in her denial of the motion for new trial on page 45, footnote 30 of my brief. She set forth all of the reasons why she thought that it was the defendant, and she included the fact that it was the defendant who had called Greta and said, tell DCF that it was Lexi, and the fact that he had all these stressors in his life. And I don't think that the word motive is the perfect word for it. It's not a motive to harm a child, but it's an explanation for why a father would commit such an atrocity against his child, having all of these things. There's no evidence that Sam did live in the same place, but there's no evidence of all the other stressors or factors in her life. He had told Greta that he hated his wife, he didn't want to be there, the baby crying. There's no similar evidence as to Sam. And the Commonwealth does not have to prove that it could not have been Sam, or that the defendant was the only person who could have injured the child, just to provide sufficient evidence for a rational jury to find beyond a reasonable doubt that it was the defendant. So there's a lot of evidence at trial that distinguishes the defendant's conduct.
Can you just say what you just said?
Yes.
Again? Why didn't the Commonwealth have to prove that it was the defendant that did this when the fact finder found him not guilty of permitting it? Are you saying that this could have been a joint venture theory?
Oh, well, no, absolutely not. I am merely noting.
So it's fair to
That's
say
not a complication. The Commonwealth does not.
prove.
If they had to prove that he did it beyond a reasonable doubt, they did not have to prove that no one else could have done it. And there are several cases that I cite in my brief for that exact proposition. If the court will just indulge me for one moment. On page 38, I cite Commonwealth versus Leach from 1894, which says the Commonwealth need not prove at trial the crime could not have been done by anybody else other than the defendant, or that no person other than the defendant had an opportunity to do it. And then I cite a case of this court from 2002, Commonwealth versus Cromwell, in which the court said it is not necessary to prove at trial that the defendant had the exclusive opportunity to commit the crime. That's all I'm saying. I'm definitely not saying that there's any joint venture involved here at all. Also, there's evidence that I didn't mention in my brief that goes to your point about why the defendant and not Sam. There was extensive evidence that when they arrived at the emergency room, Brandon had the appearance of being fine, and it was the defendant who persistently insisted he has to be admitted, he has to stay. Now, a fact finder could have said, well, that's just because he's a concerned parent and this child has had some problems in the past. But the jury could also find that he is that insistent because he knows that there's other problems with the child that he has inflicted. And in fact, during defense counsel's closing argument, Judge Ames asked him about that very point. She was very concerned. She said, well, I am concerned about how insistent he was that that child be admitted, even though that child appeared fine, which is strong evidence that the defendant himself, rather than Sam, knew about these injuries to his child and that he had inflicted them on him rather than Sam.
Counsel, did Dr. Newton, and I think you heard me ask
Yes.
your sister this question, and I have read the transcript, and maybe I missed it. Did Dr. Newton give any explanation as to why there would have been some time frame? And again, I know there's a discrepancy, whether it be 2 or 3 hours from a baby appearing seemingly fine to having this dramatic turn for the worse, and having that correlate to shaken baby syndrome, if I can.
I do not believe so, and I'm fairly sure that she did not. But, of course, it's implicit when she says this injury could have occurred any time between 30 minutes and 4 or 5 hours, that it takes some time. And I know from other cases, I don't know whether this court could take judicial notice of it, but brain injuries often take a while to manifest themselves. They don't immediately become apparent. But no, she did not testify exactly the biological processes by which it takes a while for the symptoms of this injury to manifest themselves. I don't think that's in the record, but I think it's enough that she said that this amount of time had passed before the symptoms started to appear. So it's implicit in that there is a process that the brain, when it suffers that kind of injury, does not show those injuries immediately. But no, there's no such evidence that I'm aware of on the record from Dr. Newton's testimony. I also think that to the extent that my sister argues today that it was Dr. Scheller's opinion that should have governed rather than Dr. Newton's, I think it's fairly plain that that's an issue for the jury and not for this court at all. I'd point the court's direction to the conclusion of the defendant's reply brief, where the defendant says that he urges the Honorable Court to see what the trial judge could not, that shaken baby syndrome is not the explanation for Brandon's injuries. And that, of course, is not the role of this court at all, to find out, to say, no, Dr. Scheller was right, the shaken baby syndrome was not what caused this. I think that was an issue for the jury, for the finder of fact, and that Dr. Newton provided ample evidence of that it was, in fact, a product of shaken baby syndrome, and that it was this defendant and no one else who did it. Unless the members of the court have any further questions, I'd be happy to rest on my brief. I'm sorry, if there is one more thing. I filed a motion to strike footnote 2 of the defendant's brief, which contains evidence outside of the record, and that should not be considered by the court, so I'd ask the court to allow that motion.
We will rule on the motion, but we will rule on it with everything else.
I know. Thank you very much, Your Honor.
All right, thank you both. This is a very complicated case, and we appreciate your efforts very much. I'm sorry, I didn't hear that? Oh. All right, I think we've got our commuter rail users, finally.
Thank you again.
All right, calling the last case, the second case, but the last case we'll hear, 22P414, Commonwealth versus Tantillo. Counselor, both of you had quite an adventure this morning, but we're glad to have you here, and whenever you're ready.
Thank you, Your Honor. Your Honors, Attorney Kristen Friedel. Good morning. May it please the Court, on behalf of Teresa Tantillo. Your Honor, in this case, the argument I would like to start with is the insufficiency of the evidence to find the defendant guilty of negligent operation. And I would just sort of suggest first, there was 3 main categories of evidence in this case that were presented at trial, and all 3 of which had deficiencies, even in the light most favorable to the Commonwealth. The first sort of category I would like to start with is the accident. So, as the Court is aware from the transcripts, Ms. Tantillo did make 2 admissions to being in an accident. One to Detective Kramer, well, strike that, that was not part of the trial. The admission she made to Officer Cacciatore was that, yes, she was in an accident and that she had hit a pole at Cumberland Farms. I would first, on that piece of evidence, suggest that it's an uncorroborated admission. I think even under the low bar from Ford, and now the newer case, and I'm going to mispronounce this, I'm sure, Lagodic, even at that low bar, I would suggest that the admission was not corroborated. The only thing that I think the Commonwealth may be able to rely on for corroboration is damage at the Cumberland Farms, but I would suggest that the damage was unclear. It was unclear whether the damage was fresh or whether it was from the defendant herself. So even with the very low bar, I would suggest that it was uncorroborated evidence of an accident. If I have one moment, Your Honor. Your Honors.
Yeah, it's very hard to get through an argument without water.
Thank you. So the second sort of category under that umbrella of accident that I would like to address is the Osella case. And I would suggest that in Osella, although it does involve a pedestrian in a car, that it is still pertinent in this case, and this case still falls within that umbrella because the real issue in Osella is whether or not the court could determine the defendant's negligence. And I would suggest that even in a one-party or a one-car accident, the court would still have to determine that the defendant is negligent. And I think that there are other reasons why an accident involving one car could occur due to something other than negligence. For instance, a mechanical issue or something of that nature.
What about the evidence here that there was some limitation on the defendant's ability to control her physical movements?
So, yes. So that I also would like to address her condition at roadside. So I'll just skip over to that for one moment. I would suggest that in some circumstances, the condition is relevant, certainly in terms of negligent operation. But here there's a few distinctions. The first, I think, the proximity between her roadside condition and the operation. In the bench trial, the officer who stopped Ms. Tantillo did not testify. So there's a sort of a gap in that. And I would say it's a stronger case where if the defendant stopped by an officer and that officer who does stop the defendant observes the condition in close proximity to the time of the operation. But I would suggest to the court that, I mean, the real issue is the condition at the time of the operation. And so that's the first difficulty, I think, with that piece of evidence is just the proximity, given the fact that that officer didn't testify. The second issue, I believe, with that sort of analysis is back under Zagwin, which I think I put under the accident umbrella. But in that case, the court essentially said that there has to be something more than just the operator being under the influence. And I think in the Zagwin case, our officers essentially said that it was the taillight was out, and I think there's one other sort of minor motor vehicle thing, nothing that rose to the level of negligent operation. And I think that can be, I think that applies here as well, not just for intoxication, but also for the condition of the driver. And I would just say, pointing to some of the cases I think the Commonwealth cites to, Ross, Gordon, Souza, Texera, what is missing in those cases, or what that case has that this case doesn't, is the condition or the, in those cases, it's alcohol or substance use, plus something else. So I think that Zagwin can still be applied in a case as is here, where it's not necessarily taking the prescription medication use out of the equation for 1 second, just the condition itself. There has to be something in addition to just the condition of the defendant at the time of operation in order to find them negligent, that they were negligently operating the car.
So the condition of the defendant plus that she hits a pole in a parking lot, you don't think that correlation is enough?
Well, no, not in this case, because, as I said, it's uncorroborated. So and again, I think the only slight evidence that the Commonwealth could point to is damage to a pole, but the officers testified in the bench trial that they were unable to tell or ascertain if Ms. Tantillo created that damage or if it was fresh. So without that, I don't think that here we have that sort of situation. And just kind of going back to that, let me strike that. So that is my suggestion. If, as Your Honor suggests, the evidence of the accident was corroborated by something in addition to her admission, then I would absolutely agree with that proposition. And I just wanted to point out too, as I was discussing in some of the cases cited by the Commonwealth, again, Ross, Gordon, Souza, Texera, at least in Gordon, in that instance, the operator in that case actually, I think, struck a house, a parked car. In Souza, in addition to narcotic ingestion, the defendant's vehicle rolled through a stop sign. They appeared to be asleep. They were speeding, stopping and starting. Texera involved alcohol, and they were driving below the speed limit while holding a cell phone. So I think, and again, applying that to this situation, I think that Zagwin does this falls under that umbrella that it has to be something more than just the condition alone. There has to be some evidence of improper driving. And to the point that I believe the Commonwealth may make regarding the jury instructions that it's not, the defendant doesn't have to actually put the lives and the safety of the public in danger. They just have to drive in a manner that could. I think that, again, is relating back to not that there can't be, or not that the court can find negligence without bad driving, because I don't think the court can, given what I've just cited. If there's no further questions on that issue, move on. Okay. Just now talking about the second sort of category of evidence, which is the prescription medication use. So I would suggest that generally, the fact that a defendant has ingested alcohol or narcotics is relevant to whether they're operating to endanger. But here, there's just not enough evidence of that. Even though Ms. Tantillo admitted to taking her prescription medication, there's no evidence as to what time she took the medication other than that day, or what quantity the medication was in. Likewise, I would point out that there were no evidence as to any potential side effects of that medication.
Counsel, again, I'll go back to the testimony of the officer. She was very unsteady on her feet. She had to hold onto the car a lot to keep her balance.
Right.
Something caused that.
Correct.
So isn't it a fair inference that in the absence of anything else, it was the medication that may have caused that?
I don't think so, because, well, one, I don't believe there was an absence of anything else. She indicated that she had anxiety, that she was nervous and lost, and she also indicated that she had a fractured ankle.
But if you have a fractured ankle and your nervousness and anxiety cause you to be unable to even stand without holding a car, should you really be driving?
And again, I think that goes back to the point of the proximity of her roadside condition to the operation. So if there was evidence of the officer who conducted the stop of Ms. Tantillo and said she had that same condition present, then I think that's a fair inference. But here, we have an officer who never testified who conducted the stop, and then Officer Cacciatore comes upon that at some point later. I'm not sure that it's clear in terms of the timing, what that may be. So that's what I'd say, the proximity issue there. And again, even if her condition was one that maybe perhaps not under the negligence standard that she shouldn't be driving, I still would suggest it falls under Zagwin, because in Zagwin, even if their condition is that they are inebriated, that's not enough for negligent operation without something else. So that would be my argument on that. And just moving on to, and actually just to talk a little bit more about, I think the issue, as Your Honor pointed out with the causation, that's between the ingestion of the medication and her condition. That's another problem with the Commonwealth's case. Even in the light most favorable to the Commonwealth, there was no evidence as to the effects of tramadol or clonazepam. And I think that's required to have a causal connection between the two.
Well, that might be true as to the OUI drugs, which maybe that's why she was found not guilty of that.
Right.
But what requirement is there of that causal connection when, again, you have a defendant unsteady on her feet so much that she has to use the car for balance? Can't there be a fair inference that something caused that, and because she had just mentioned that she was taking medication, that it's a fair inference to say the medication's causing that?
I would not think that's a fair inference, no. I think that in just touching upon the cautionary statement, for instance, as an example, I think that a cautionary statement could be cautioning against don't take this medication while breastfeeding or while pregnant.
I'm not talking about the label, the cautionary. Maybe we'll get to that with the Commonwealth. What I'm saying is you're saying that there's not enough to connect the drugs to her condition. And I'm saying that isn't it a fair inference that her condition, something caused that? A fact finder can say something is causing this condition, and the evidence the fact finder has is she's on this medication.
So I understand Your Honor's point, but I don't think that's a fair inference without any indication as to what the side effects of the medications are. So without an expert testimony as to what side effects of tramadol are or clonazepam are, I'm not sure how that inference can really be drawn. Certainly something's causing it, but I don't know that that causal connection can be made, and I'm not sure that it's really necessary in terms of the case. And just moving on, because I see I'm getting short on time, on to unless there's any questions on that. The judicial notice of the cautionary statement, I suggest that that was improper in two ways. First, I think it's relevant to this case, again, as we've already discussed, that evidence of ingestion of medication or alcohol is relevant in terms of negligent operation, which is why I brought it forward in the appeal. I would suggest that the judicial notice was improper because it was not a subject for expert review. It was not a subject for judicial notice because it needed expert testimony, and I think that is either Green or Greco I cited to. And additionally, that it was hearsay based on the inference that was given to the cautionary statement. So, yes.
I don't know, based on the evidence, what that cautionary statement was. I have no idea.
Right.
So I'm kind of missing, if I have no idea, i.e. the fact finder had no idea, how that can be hearsay.
So,
It
this
has
is
to
what
be admitted for the truth of the matter, and I don't even know what the statement is, so how can it be hearsay?
Sure. So this is what I would say about that. The relevancy of the cautionary statement derives from what they're cautioning against. So as I was just starting to say before, if, let's say, it was cautioning against a pregnant woman taking the medication, then it wouldn't have been relevant. So for the judge, in order for the judge to allow that judicial notice, implicitly...
But he rules on this at the beginning of the trial. He doesn't know what's going to come in. He doesn't know whether there's going to be pictures of the labels or whether evidence. It seems kind of a stretch to suggest he's ruling that it will later be relevant. No one moves to strike it, right?
Well, it's not... I believe it's objected to, or no, strike that.
It's opposed, but it's
Right.
all at the beginning of trial.
Right. So I can move on from that issue and get to...
You don't have to,
Well, I think we have a bit left.
but you certainly can.
Get to the motion to suppress, yes.
I'm trying, so on the motion to suppress statements, I understand commonly the roadside stops are not custodial. I think here the situation was different. I think Merritt is a great case for that, especially in the footnote, although it's a footnote.
You don't have to go so fast. We'll give you another 2 minutes.
Thank you. So I think that for a few reasons. So first, there's two statements that I really think that should have been suppressed: the admission to the accident and the admission to the medication or ingestion of the prescription medication. Initially, I think the trial or the judge in the trial court indicated that he thought it was a preliminary investigation. I would suggest that the record reflects that it was not a preliminary investigation at all. At the time that Officer Cacciatore asks Ms. Tantillo about if she was in an accident.
Why isn't that a preliminary investigation question? Again, maybe a couple of questions later, you might have me. But, hey, were you involved in an accident? And the answer is, at the motion to suppress, is maybe. Why isn't that preliminary?
So that's not the statement, it's a secondary statement where Officer Cacciatore then asks again.
Okay.
So the reason why, once Officer Cacciatore approaches, after Detective Kramer is done, their preliminary investigation's over. At that time, the officers knew that a 911 caller said that there was an older blonde woman who appeared intoxicated, hit a pole and drove away. The car matched the description, the defendant matched the description, the plate number was consistent, they saw damage to the hood. She's located only a short place away from where it occurred, and she had indicated maybe she was involved in an accident. At that point, there's no preliminary investigation. It's not similar to Kerwin or Merritt, where they're trying to either dispel or confirm a suspicion. They know at that point, I would suggest. So going and asking her a second time, that's where the custodial interrogation begins. And I would suggest that a lot of the cases the Commonwealth cites to about an officer's subjective belief, in this case it's different because that belief was relayed both directly and indirectly. And I think I am over my time now. Thank you very much.
Thank you very much.
Thank you.
Would you just hold on a sec? Professor, thank you. Thank you to all the students. Sorry we couldn't get the schedule a little better for you.
Thank you, Your Honor. We also are subject to transportation and getting back to campus for afternoon classes. But I want to thank you for agreeing or at least offering to meet with us after the fact that alas, time calls.
Hopefully next time.
Thank you.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Would ask the panel today to find that the judge did not commit any error in denying the motion to suppress. Start with that issue as it was first in the brief. It's the Commonwealth's position that this was not a custodial interrogation. Simply asking a question again does not suddenly turn an investigatory stop or a preliminary investigation into a custodial one.
Counsel, in your brief, you talk about this as a regular motor vehicle stop, i.e. after a motor vehicle infraction. You would agree that's not this case. It's a different type of stop, isn't it?
Meaning?
She didn't commit any motor vehicle infraction. It's not like she went through a red light. They're investigating
Correct.
whether this car was involved in an accident at CVS. You would agree with that?
I would agree with that. I would agree that it would be the Commonwealth's position that they had reasonable suspicion based on the information they had to investigate and to see a vehicle that had damage to the hood, that had matched the description, that had the same license plate as what was just relayed to them by the identified 911 caller, that, yes, that they then stopped the vehicle. And I know my sister mentioned that it is true, the detective or the officer who actually stopped the vehicle did not testify, but it did come in, as you are aware in the transcript, from Officer Cacciatore that she was listening to the radio, that she heard transmission that the vehicle was no longer in the area, but that Officer Kramer or Detective Kramer saw the vehicle, pulled it over. That testimony came in and was allowed, so the fact finder, the judge, had that information. So it was close in time. We do have a sense of how close in time it was because then Officer Cacciatore testified, so I didn't proceed to Cumberland Farms. I went to where Officer Kramer was. I saw them. I pulled in behind them. I got out. So it gives us a sense of the timeline, even though they're not relaying timestamps or anything of that nature. So correct, they had, this was a stop not because an officer observed a motor vehicle infraction, but because they had this information. With that being said, if they approach an individual and she did not seem confused and didn't appear that she had any issue and was fine, they would have said, thank you, and sent her on her way. But that's not what happened. She was very confused. She told them that she left her home at 2:30, and 2:30 hadn't even happened yet. It was a little after 2 o'clock. She was very slow to respond. Like, they were making...
But I think counsel's argument is before you even get to those questions, it should be suppressed. So let's try to take it chronologically.
Okay.
The first officer that stops, that doesn't testify at the hearing,
Correct.
he asks the defendant a question, and that comes out during the hearing. What is that question and what is that answer that the judge hears? The very first officer.
My recollection is that he asked if she was in an accident, and she responded, maybe.
Okay. So we've got a maybe, so a preliminary investigation question, no doubt. Defense doesn't argue to that. What's the next question, though? It's not about how are you feeling, how is everything. It's pointed directly at the accident, isn't it?
I'm having trouble recalling, but yes, I do agree that they were questioning, but I would submit to the court that if you're asking someone if they've been in an accident, and they're answering maybe, that there's something going on. Either they've sustained an injury and they're not sure they were in an accident, or they're attempting to mislead in some way, and it would be perfectly reasonable to then ask follow-up questions to try to ascertain what is happening. Whether no crime has been committed and she just needs medical attention. That it would be unreasonable for them.
See, that's where I'm losing you, and I got that from your brief. They know a crime has been committed at that point. There's no doubt that that car, based on what they know, that car was involved in an accident. That's what gave them reasonable suspicion to stop the car. So they know that car is involved in an accident, and based on the timing which you just mentioned, I think they have a pretty good feeling that this defendant is the one that was involved in that accident. So I'm not quite sure what this preliminary investigation is at this point. It seems to be focused on, you're the driver. Weren't you involved in an accident? And how isn't that interrogation? Custody might be a different issue, but how isn't that interrogation at that point? They're focusing on the crime itself. They're not asking general, how are you feeling? Are you okay? They're asking specifically about the crime that they had reasonable belief to believe that defendant committed. Isn't that exactly what interrogation is?
I apologize. If I'm recalling correctly, you can have, yes, it could be interrogation, but I seem to recall that, and I apologize, I'm drawing a blank, the case name, but I do believe I did cite one. If not, I would be happy to submit a 16L to this point. But I seem to recall that there was a case regarding investigation, I believe it was a murder, and they had some suspicion and they were asking people, and even though they had an idea and they had information ahead of time, that the minute the person makes any sort of, okay, yeah, I was in the area, and they in their minds know that's the person, they don't just arrest and end everything. They can continue to, it doesn't turn it at that point into custodial interrogation. And I think that's the distinction that I was attempting to make in my brief. They may believe that she did commit a crime, they may believe she is the one, they may be asking questions to further that, but it doesn't necessarily mean that it is custodial at that point. Similar to when you pull someone over for, let's say, if an officer observed the stereotypical OUI, if you will, swerving of lanes and that type of thing, they pull the person over, they can be asking them questions, have you had anything to drink tonight? If the person says, yeah, I had 2 beers, if they've watched them swerve lanes and they admit they've had 2 beers, it doesn't become custodial at that point.
I'm trying to distinguish from your brief the part of interrogation versus custodial. Because the case law, it seems to me, talks about the preliminary investigation. I'm going to call it an exception, even though maybe it's not as... Those aren't interrogation questions. Those are preliminary in the sense of they're trying to find out what the heck's happening here. They don't know, or they have an idea and they want to know what's happening. That's different than questioning that focuses on the crime itself that they know. Then what we have is, if that's interrogation, if that's questioning, is it custodial? And I thought your brief kind of merge the two, and I'm trying to figure out whether they should be merged or not. This may not be custody. Motor vehicle, you know, is the person in custody, reasonable person in their minds. I get that. But I'm focusing on the questioning, because that's what the judge found. The judge found that this was not really questioning about a crime. It was preliminary questions that an officer is entitled to do. So which is it here? Do you agree that it's interrogation or that it's preliminary questioning? And if it's preliminary questioning, I'm trying to figure out, in this case, what's the difference? I mean, they're focusing on the crime. So how is that preliminary questioning?
I don't believe that's something I can answer at this moment, but as I said, I would be more than what I've already submitted in the brief, but I would be more than happy to submit a 16L letter more specifically and try to tease that out. I guess on that point, I would have to rest on what I submitted, and I apologize that I don't have a better answer to that.
The case law is, it's a mixing of the two sometimes. I just see it, they're being aligned here.
I understand.
And I'm trying to flush that out a little bit.
I understand, and I think I was in a different place in the brief, obviously. I don't know if there are any further questions on that topic, or any questions in regards to any of the other issues that were raised by the defendant. As I mentioned in my brief on the other topics, the Commonwealth's position that there was no error in this bench trial, that the judge can properly instruct himself, and that the way the verdict came out was correct in regards to the OUI and there not being an expert, et cetera, and that all of the other evidence would go to the negligent operation.
Do you think the cautionary instruction judicial notice has any, if we find it was error for the judge to take judicial notice of that based on the evidence that actually came in at trial, do you think that has anything to do with the operating negligently charge, or could we find that was harmless error?
I think it could be found to be harmless error, because even if you didn't have that even if the judge had said, no, I'm not going to take judicial notice of that, and the evidence came in just as it came in, you still could find a negligent operation because of all of the other factors that were brought out: her confusion, her inability to stand, her inability to answer questions.
Test for prejudicial error is not whether you could have found someone guilty nonetheless, but whether you would have. What effect do you think the judicial notice had on the negligent operation decision? I mean, obviously it was aimed at the OUI, but that appropriately didn't go anywhere.
Correct. It was aimed at the OUI, and it didn't play out that way. And obviously the Commonwealth did not have an expert to be able to speak to all of the things that you likely would need to have entered in order to find the OUI. But again, I think this situation being a bench trial is a little bit different than if it had been a jury trial. Here, the judge allowed the judicial notice, then saw the evidence come in. I would presume that if that particular piece, if it was not appropriate to consider it for the negligent operation, that the judge would then properly instruct himself and not consider what shouldn't be considered. And I think if it had been in front of a jury, we'd be looking at what the judge's instructions were in regards to it, but we don't have that here. So I think it's the presumption that the judge instructed himself and considered the appropriate evidence in coming to a verdict.
All right, thank you very much.
If there are no further questions, I will rest on my brief, and again, I apologize for the circumstances this morning.
Not your fault, beyond your control. Ms. Friedel, I know you're an experienced criminal attorney, but I think this is the first time we've had the pleasure. So this was quite an excellent way, quite an excellent performance, not a happy way of doing your first argument. I know you got a few more in the works, and I think we're all looking forward to seeing you here a lot.
Thank you.
That's the experience you get. So I just want to thank our timekeeper, thank our court officers, thank our clerk. We've had our own technical difficulties that we managed to work out enough, at least to get here. And of course, our court officers and our clerk's office have been keeping us in constant knowledge of your status and where you are, and we appreciate that as well. And with all that, court stands adjourned until Monday, hopefully in the other courtroom, but who knows?